Understanding human relations. Human relation is the interaction or interrelation of one person to another person or relationship of persons among each other in accordance with mores, habits, customs, and public policy which are not contrary to laws. It is based on the old adage or a motto or a golden rule: do not do unto others what others don't do unto you. According to Kate Davis, human relations is an area of management practice which is concerned with the integration of people into a work situation in a way that motivate them to work productively, cooperatively, and with economic, psychological, and social satisfaction. Human relations are the relations between human beings that are affected by many other factors, and it helps in the accomplishment of goals of an organization. The performance of people in an organization depends mainly on three factors, namely technology, ability, and motivation. Human relations is the key to generate the willingness among the employees. Productivity and progress in industry or in an organization can be achieved only by human approach to labor problems. In short, human relations is the process of training employees, addressing their needs, fostering the workplace culture, and resolving conflicts between different employees or between employees and the management. Sources of understanding human behavior. Psychology or biological. Psychology is a broad and diverse field that encompasses the study of human thought, behavior, development, personality, emotion, motivation, and more. As a result, some different subfields and specialty areas have emerged. It is biological because it focuses on the nervous system, particularly hormones and genetics. It examines the relationship between mind and body, neural mechanisms, and the influence of heredity on behavior. Next, philosophical or ethical. So there is a link between philosophy and ethical behavior because philosophers describe human behavior and how humans should behave. Most particularly, they need to follow the rules of the society, their church, or some other developed from philosophy. For example, focus on rational decision making. If we say rational, we are referring to normal decision making. Another example is the Aristotle's ethics. According to Aristotle, ethics needs to be practical rather than theoretical study. Like for example, one aimed at becoming good and doing good rather than knowing for its own sake. Next, theological or moral. As we all know, theology is the study of religion, plain and simple. Of course, religion isn't simple, so theology covers a lot of subjects like rituals, divine beings, the history of religions, and the concept of religious truth. The theological perspective starts by assuming that the divine, however defined, is real and that religion is a response or approach to spiritual realities. At the very least, the theological perspective is willing to entertain the possibility of the existence of God. Republic Act number 386, an act to ordain and institute the Civil Code of the Philippines. Civil Code of the Philippines is the basic law governing persons and family relations, property and property rights, ownership of modifications, the modes of acquiring ownership, and the obligation and contracts. So we are now on lesson 2, human relations provision under the Civil Code of the Philippines. By the way, human relation provisions can be found on Chapter 2, Article 19 to 36 of the Civil Code of the Philippines. Under Article 19 of the Civil Code, it states that every person must, in the exercise of his rights and in the performance of his duties, act with justice, give everyone his due, and observe honest and good faith. So this prevents a certain person from abusing the rights that he may otherwise have against another. So this is applicable only when there is an abuse of right or abuse in the performance of duty. In relation to Article 19, we have the Latin maxim damnum absque injuria, which basically means loss or damage without any injury. It is a principle in law of torts which mainly refers to a situation when a person suffers damage or loss but does not suffer any kind of injury. In simpler words, it means that although there was some physical damage, but there was no legal injury. Injury in the legal invasion of a legal right, while damage is the loss, hurt, or harm which results from injury. There can be damage without injury in those instances where the loss or harm is not the result of a violation or a legal duty. For example, okay, A is driving his car, okay, within the speed limit while considering the condition of the traffic and the pedestrians at the same time. Okay, accidentally, okay, nasagasaan ni A yung stone sa daan. And, okay, so dahil nasagasaan, kaya naitama ngayon yung stone or yung bato sa mukha ni B. So, sa mukha ni B, nagkaroon ng malaking damage, particularly injury. So, nagkaroon siya ng injury. So, with this particular situation, okay, uh, although nagkaroon ng injury yung ating or si B, okay, it does not mean or does not give any right to B, okay, to give rise to any cause of action. So, the fact na sinundan or finalo ni A yung speed limit, okay, at kinonsider din niya yung traffic condition while driving, including the pedestrian. So, that's an example. Torts law in the Philippines is the blending of common law and civil law system. Quasi-delict or tort refers to acts or omission causes damage to another. There is being fault or negligence is obliged to pay for damages done or damages suffered by the plaintiff. In short, torts protect people from wrongful conduct by others and give claimants a right to sue for compensation or possibly an injunction to restrain the conduct. Rights versus duties. Rights are legal, social, or ethical principles of freedom that people are entitled for by a governing body. These are based on beliefs and values, equality, freedom, and justice. There are examples like the right to vote and hold office, the right to say what you think in speech or in writing, the right to practice your own religion, and the right to a fair trial, and others. On the other hand, duties are responsibilities or obligations of an individual by the governing body that are required to be done by the said individual. So, by performing our duties as citizen, okay, that's our way to support the government, or that's our way or effort, okay, to meet our needs, okay, based on the needs also of the society. Some of the example we have obeying the law, defending the nation, serving as witness in court, paying taxes, attending school, and others. Two kinds of rights, the negative rights and the positive rights. If you say negative rights, it refers to the duty that others have to not interfere with actions related to a person's rights. It prevents a person from doing something that would deprive another person of a right. They are rules that keep the state from depriving individuals of liberty. Example, we have freedom of speech, freedom from oppression by the government, freedom of religion, right to bear arms, and the like. Next, positive rights. It imposes a duty on others to provide for their needs, most especially to achieve their goals, not just to protect their right to pursue them. It requires action or initiative to ensure that right is protected. They are rules that require the state to provide individuals with benefit. Example, right to education, right to choose your own government, right to a job, right to a housing, right to healthcare, and others. Article 21 of the Civil Code of the Philippines states that any person who willfully causes loss or injury to another in manner that is contrary to morals, good customs, or public policy shall compensate the latter for the damage. Every person who, contrary to law, willfully or negligently causes damage to another shall compensate the latter for the same. Take note that under Article 21, it provides liability even without violation of a law. Hence, if the loss or injury is contrary to morals, good customs, and public policy, liability may still arise under this article. The injury suffered may refer to any determinate right or property, whether material or otherwise, so long as the requisites of willfulness and contravention of morals, good customs, or public policy are present. This provision only covers willful act. Take note, willful act must be present. It is willful if it is done with knowledge of its injurious effects. However, if it is not required that the act be done purposely to produce the injury. Exception to the rule, we have volenti non fit injuria. It is one of the defense under the law of torts in which person who has committed a wrongful act is exempted from liability because the victim of such a wrongful act gives his consent to the commission of such an act. And such a consent must be free for the successful application of this defense in a case. Volenti non fit injuria means where the sufferer is willing, no injury is done. In other words, when a person consents to the infliction of some harm upon himself, it does not constitute a legal injury and therefore it's not actionable. Consent to suffer the harm may be expressed or implied. It can be inferred from the conduct of the parties. So, express or the parties must express consent. Example, when you send an invitation card and invite somebody to your house, you cannot sue him for uh, trespassing. Or, okay, for example, when you submit yourself for surgical operation, so you cannot sue the hospital or the hospital authorities for doing the same. Take note, it is very necessary that the consent of the party must be expressed in this particular article. Article 22 of the Civil Code of the Philippines states that every person who, through an act of performance by another or any other means, acquires or comes into possession of something at the expense of the latter without just or legal ground, shall return the same to him. There is unjust enrichment under Article 22 of the Civil Code when a person is unjustly benefited, and such benefit is derived at the expense of or with damages to another. Article 22 also embodies the maxim of nemo ex alterius incommode debet leco pletari, which means no man ought to made rich out of another's injury. The doctrine of unjust enrichment or dissolutio indebti, this particular doctrine essentially contemplates payment when there is no duty to pay and the person who receives the payment has no right to receive it. Article 23 of the Civil Code of the Philippines states that even when an act or event causing damage to another's property was not due to the fault or negligence of the defendant, the latter shall be liable for indemnity if through the act or event he was benefited. Okay, question. Can a person be liable of another even he committed no fault? Okay, the answer is yes, if through the act or event he benefited. Okay, so what is liability without fault? This concept is based on equity. An involuntary act, because of its character, cannot generally create an obligation, but when by such act its author has been enriched, it is only just that should indemnify for The damages goes to the extent of his enrichment. Liability without fault is a circumstance in which the defendant is held criminally liable for his action even though criminal intent is absent. In other words, cases of liability without fault requires only actus reus. If we say actus reus, we are referring to the act or omission that comprise the physical elements of a crime as required by the law. Example of actus reus in the crime of theft. The actus, the actus reus of the crime of theft is taking someone's property without the consent of the owner, or for the crime of murder, brutally or unlawfully killing another person. So these are examples. Article 24 states that in all contractual property or other relations, when one of the parties is at a disadvantage on account of his moral dependence, ignorance, indigence, mental weakness, tender age, or other handicap, the courts must be vigilant for his protection. So take note, vigilance for the protection of the weak. Okay, according to the prominent justice, this particular article must be meant that in case of doubt, it should be resolved in favor of the underdog. If we say underdog or weak, we are referring to those who are morally dependent, okay, ignorant, indigent, mentally weak, tender age, and handicap. Article 25, thoughtless extravagance in expenses for pleasure or display during a period of acute public want or emergency may be stopped by order of the courts at the instance of any government or private charitable institution. This particular article, okay, or provision reaffirms one of the sovereign powers of the state, which is known as the police power. If we say police power, we are referring to the inherent power of a government to exercise reasonable control over persons and property within its jurisdiction in the interests of the general security, health, safety, morals, and welfare, except where legally provided. And this article is necessary towards the attainment of social stability. If we say social stability, we are referring to the degree to which a society and its institutions remain predictable and reliable. So this is important because it allows participants, particularly the society, or such individual and groups to plan and conduct their affairs without disruption. Article 26. Every person shall respect the dignity, personality, privacy, and peace of mind of his neighbors and other persons. The following and similar acts, though they may not constitute a criminal offense, shall produce a cause of action for damages, prevention, and other relief. Prying into the privacy of another's residence, meddling with or disturbing the private life or family relations of another, intriguing to cause another to be alienated from his friends, and vexing or humiliating another on account of his religious beliefs, lowly station in life, place of birth, physical defect, or other personal conditions. Article 27. Any person suffering material or moral loss because a public servant or employee refuses or neglects without just cause to perform his official duty may file an action for damages and other relief against the latter, without prejudice to any disciplinary administrative action that may be taken. Take note that there are common story that public has heard about Lagayan system. This was said happen when public officer without just cause excuse delays or to the extent of he will refuse to perform his duty until he gets some valuable considerations, or this what we call lagay. So according to Bibar, there are three kinds of bribes. We have pabagsak. If we say pabagsak, the gift is given so that an illegal thing may be done. We also have pampadulas. The gift is given to facilitate or expedite the doing of a legal thing. And okay, another one, pampasalamat. The gift is given in appreciation of a thing already done. Article 28. Unfair competition in agricultural, commercial, or industrial enterprises or in labor by force, intimidation, deceit, machination, or any other unjust, oppressive, or high-handed method shall give rise to a right of action by a person who thereby suffers damage. The Civil Code prohibits unfair competition. To qualify the competition as unfair, it must have two characteristics. One, it must involve an injury to a competitor or trade rival. Second, it must involve acts which are characterized as contrary to good conscience or otherwise unlawful. The public injury or interest factor appears to be a minor aspect. The essence of the matter appears to be a private wrong perpetrated by unconscionable means. So, what is commonly known as cutthroat competition? For instance, it is considered unfair when a person starts a business that directly competes with another, not for the sake of profit for himself and regardless of loss, but for the sole purpose of driving his competitor out of business so that later he can make advantage of the effects of his malicious purpose. The person may be guilty of unfair competition under the Civil Code. The broad concept of unfair competition under this particular article may cover cases of discovery of trade secrets. If we say trade secrets, we are referring to the formulas, processes, um, which are considered to be intellectual property. Okay, so if this particular trade secret is being discovered by the competitor and they will make use of it in making their products, then that's another violation under this article. Bribery of his employees, a misrepresentation of all kinds, interference with the fulfillment of a competitor's contract, or any malicious interference with the latter's business, which cause damage or injury to another person. Article 29. When the accused in a criminal prosecution is acquitted on the ground that his guilt has not been proved beyond reasonable doubt, a civil action for damages for the same act or omission may be instituted. Such action requires only a preponderance of evidence. If we say preponderance of evidence, we are referring to the evidence with a greater weight. Upon motion of the defendant, the court may require the plaintiff to file a bond to answer for damages in case the complaint should be made to be malicious. If in criminal case, the judgment of acquittal is based upon reasonable doubt, the court shall so declare. In the absence of any declaration to that effect, it may be inferred from the text of the decision whether or not the acquittal is due to the or to that ground. Can a person file an independent civil action without reservation? The answer is it depends where the civil liability arises. If the liability is arising from a delicт or a mere violation of law, reservation is necessary in connection with Article 100 of the Revised Penal Code, or otherwise known as civil liability of a person guilty of a felony. And Rule 111, Section 1 of the Rules of Court, or otherwise known as Institution of Criminal and Civil Action. If the liability is based on the other sources of obligation, no need for the reservation. Take note that Articles 29, 30, 35 of the Civil Code are the liability arising from a delicт which reservation are necessary. Articles 31, 32, 33, 34, and 2177 of the Civil Code, okay, there's no need for the reservation. Article 30, when a separate civil action is brought to demand civil liability arising from a criminal offense and no criminal proceedings are instituted during the pendency of the civil case, a preponderance of evidence shall likewise be sufficient to prove the act complained of. Take note, so the basis of the complaint, okay, shall be the weight of the evidence presented in the court. Article 31, when the civil action is based on an obligation not arising from the act or omission complained or complained of as a felony, such civil action may proceed independently of the criminal proceedings and regardless of the result of the latter. So this article refers to a civil action which is no longer based on criminal liability of the defendant, but on an obligation arising from other sources like the law, contracts, or the quasi contracts. If you say quasi contracts, is it is a retroactive agreement between two parties who have no prior contractual commitments, and of course quasi delicts or the torts. Article 32. Any public officer or employee or any private individual who directly or indirectly obstructs, defeats, violates, or in any manner impedes or impairs any of the following rights and liberties of another person shall be liable for the latter for damages. One, we have freedom of religion. Freedom of religion has three principal parts: the non-establishment clause, second, free exercise clause, and third, non-religious test clause. For non-establishment clause, it means that no law shall be made respecting the establishment of religion or prohibiting the free exercise thereof. Pre-exercise clause means the pre-exercise and enjoyment of religious profession and worship without discrimination or preference shall forever be allowed. And lastly, non-religious test clause. It means that no religious test shall be required for the exercise of civil rights. There are also two aspects of religious freedom. One, we have freedom to believe, and Two, we have freedom to act on one's beliefs. Next, we also have freedom of speech. And third, we have freedom to write for the press or to maintain a periodical publication. Freedom of speech and of the press implies that the right to freely utter and publish whatever the citizen may please and to be protected from any responsibility for so doing, except for as such publication from their blasphemy, obscenity, or scandalous character may be public offense, or as by their falsehood and malice they may injuriously affect the standing reputation or pecuniary interests of individuals. Next, we also have freedom from arbitrary or illegal detention. If we say arbitrary detention, okay, we are referring to unlawful detention of a person committed by a public officers or officials. Take note, for arbitrary detention, it is intended only for public officers or officials. For legal detention, unlawful detention of a person committed by a private person. Okay, to make a very specific example, for arbitrary detention, it can be committed by a police officer or law enforcers or any members or uh, employee of the government. For illegal detention, okay, this is unlawful detention committed by a private individual. Take note that arbitrary detention under Article 124 of the Revised Penal Code should be further differentiated from delay in the delivery of detained person to proper judicial authority under Article 125 of the same code. In arbitrary detention, it is sufficient that a public officer or employee without legal grounds detains a person. Hence, an important element is detention without any legal ground. In delay in the delivery of detained person to proper judicial authorities, the detention is with some legal ground. However, it became lawful only or unlawful only when the public officer or employee shall fail to deliver such person to proper judicial authority within the period of prescribed by Article 125 of the Revised Penal Code. So the prescribed periods under Article 125 are as follows: 12 hours for crimes or offenses punishable by light penalties, 18 hours for crimes or offenses punishable by correctional penalties, and 36 hours for crimes or offenses punishable by afflicted or capital penalties or their equivalent. Number five, freedom of suffrage. Freedom of suffrage is based upon the theory that the people who bear the burden of government should share in the privilege of choosing the officials of that government. Number six, the right against deprivation of property without due process of law. And number seven, the right to a just compensation when a private property is taken for public use. Question: can private property be taken from its owner? The answer is yes, but subject to the following conditions. One, that the private property is taken for public use. Two, that the owner of the said property should be paid just compensation. Three, that the due process of law shall be observed in taking of the said property. And lastly, that the taking shall be only exercised by the state or those whom the power has been lawfully delegated. If we say eminent domain, it means that this is the right of the state to acquire private property for public use upon payment of the just compensation. This can also be exercised by those to whom the said power has been lawfully delegated. And number eight, the right to the equal protection of the law. So under this particular right, okay, the Constitution guarantee that all persons are equal before the law, which means that what the Constitution guarantees is not absolute equality of all individuals, but only equality of the opportunity or protection given by the law to persons or classes of persons who are similarly situated and who therefore belong to a certain classification made by law. Take note that the Constitution can guarantee the equal protection. It's not okay. It's not violated by reasonable classification, which is based on substantial distinctions. Number nine, the right to be secured in one's person's house, papers, and effects against unreasonable searches and seizure. Okay, take note that it is a protection of number one, sanctity and privacy of a person himself. Number two, the inviolability of a person's home and his possession. Number 10, the liberty of abode and changing, okay, the same. So, liberty of abode and travel is the right of the person to have his home or to maintain or change his home, dwelling, residence, or habitation in whatever place he has chosen within the limits prescribed by law, and to go where he pleases without interference from anyone except in the interests of national security, public safety, or public health as may be provided by law. The exceptions mentioned means that the liberty of abode and travel is subject to the police power of the state. Number 11, the privacy of communication and correspondence. What is the exception of this right? The privacy of communication and correspondence shall be inviolable except upon lawful order of the court or when public safety or order requires otherwise as prescribed by law. The effect if privacy of communication and correspondence is violated. Any evidence obtained in violation of this shall be inadmissible for any purpose in any proceedings. Section 2, Section 3, Paragraph 2, Article 3 of the 1987 Constitution. Number 12, the right to become a member of associations or societies for purposes not contrary to law. The right of the people, including those employed in public and private sectors, to form unions, associations, or societies for purposes not contrary to law shall not be abridged. 13. The right to take part in peaceful assembly to petition the government for redress of grievances. The exercise thereof should not be made to depend upon the issuance of any permit. However, it may be subject to regulation, not prohibition by the state, as to when and where it should be held. Number 14. The right to be free from involuntary servitude in any form. No one should be compelled to or forced to work without his will. And number 15. The right of the accused against excessive bail. The rationale behind the right to bail is that the accused is presumed innocent until his guilt is proven beyond reasonable doubt by a final judgment. 1987 Constitution prohibited excessive bail because in effect it is a denial of bail. Number 6, the right of the accused to be heard by himself and counsel, to be informed of the nature and cause of the accusation against him, to have a speedy and public trial, to meet the witnesses face to face, and to have compulsory process of to secure the attendance of witnesses in his behalf. Right to counsel means the right of a person under custodial investigation to have competent and independent counsel, preferably of his own choice. The purpose of the right to counsel during custodial investigation is to preclude the slightest coercion as would lead the accused to admit something else. Number 17, freedom from being compelled to be a witness against oneself, or from being forced to confess guilt, or from being induced by a promise of immunity or reward to make such confession, except when the person confessing become a state witness. Take note that this is a right against self-incrimination. Number 18, freedom from excessive fines or cruel and unusual punishment unless the same is imposed or inflicted in accordance with the statute which has not been judicially declared unconstitutional. So a fine can be considered excessive when it is clearly shown that the nature of the violation compared with the fine is dis- disproportionate, or if it exceeds the utmost limit of the punishment which the vindication of the law demands. So, when can we consider that punishment is cruel? It is cruel if it is flagrantly and plainly oppressive, wholly disappropriate to the nature of the offense as to shock the moral sense of the community. And number 9, freedom of access to the courts. Free access to the courts and quasi-judicial bodies and adequate legal assistance shall be denied or shall not be denied to any person by reason of poverty. This is under Section 11, Article 3 of the 1987 Constitution. In any of the cases referred to in this article, whether or not the defendant's act or omission constitute a criminal offense, the aggrieved party has the right to commence an entirely separate and distinct civil action for damages and for other relief. Such civil action shall proceed independently of any criminal prosecution and may be proved by preponderance of evidence. The indemnity shall include moral damages. Exemplary damages may also be adjudicated. The responsibility herein set forth is not demandable from a judge unless his act or omission constitute a violation of the penal code or other penal statute. Article 33, in cases of defamation, fraud, and physical injuries, a civil action for damages entirely separate and distinct from the criminal action may be brought by the injured party. Such civil action shall proceed independently of the criminal prosecution and shall require only preponderance of evidence. Article 33 speaks of separate and independent civil actions even if the basis of the liability is the act or omission complained as a crime, as long as the case is one of defamation, fraud, and physical injuries. The underlying purpose of the principles under Article 33 is to allow the citizen to enforce his rights in a private action brought by him, regardless of the action of the prosecutor. It is not conducive to civic spirit and in individual self-reliance and initiative to habituate the citizens to depend upon the government for the vindication of their own private rights. Is it true or it is true that criminal prosecution is proper, but it should be remembered that while the state is the complainant in the criminal case, the injured individual is the one most concerned because it is he who has suffered directly. He should be permitted to demand reparation for the wrong which peculiarly affects him. Article 34. When a member of a city or municipal police force refuses or fails to render aid or protection to any person in case of danger to life or property, such peace officer shall be primarily liable for damages, and the city or municipality shall be subsidiarily responsible therefore. The civil action herein recognized shall be independent of any criminal proceedings, and a preponderance of evidence shall suffice to support such action. So, under this article, primary liability is assessed against the member of the police force who refuses or fails to render aid or protection. Subsidiary liability is imposed on the city or municipality concerned in case of insolvency. By virtue of this article, the city or municipal government concerned can be sued for its subsidiary liability. Incidentally, this article does not grant to the government the defense of due diligence in the selection and supervision of the policeman. Article 35. When a person claiming to be injured by criminal offense charges another with the same for which no independent civil action is granted in this code or any special law, but the justice of the peace finds no reasonable grounds to believe that a crime has been committed, or the prosecuting attorney refuses or fails to institute criminal proceedings, the complaint may bring a civil action for damages against the alleged offender. Such civil action may be supported by a preponderance of evidence. Upon the defendant's motion, the court may require the plaintiff to file a bond to indemnify the defendant in case the complaint should be found to be malicious. If during the pendency of the civil action, an information should be presented by the prosecuting attorney, the civil action shall be suspended until the termination of the criminal proceedings. This article applies to cases when there is no independent civil action, such as when the liability suit to be recovered arises from a crime and not to a tortious action such as that provided under Article 33. Example, a woman accused her classmate of committing against her the crime of unintentional abortion. but the fiscal refused to institute criminal proceedings. She may bring a civil action for damages against the alleged offender, but if during the trial an information should be presented by the fiscal charging the classmate with the crime, the civil action shall be suspended until the termination of the criminal proceedings. Article 36. Prejudicial questions, which must be decided before any criminal prosecution may be instituted or may proceed, shall be governed by rules of court which the Supreme Court shall promulgate and which shall not conflict with the provisions of this code. A prejudicial question is one which must be decided first before a criminal action may be instituted or may proceed because a decision therein is vital to the judgment in the criminal case. In the case of People versus Adelo Aragon, the Supreme Court defined it as one which arises in a case, the resolution of which question is a logical antecedent of the issues involved in said case and the cognizance of which pertains to another tribunal. The prejudicial question must be determinative of the case before the court. This is the first element. Jurisdiction to try the said case or the said question must be lodged in another tribunal, and this is the second element. Thank you so much for listening or watching this video. For your questions, you may send me a message or you can post your questions in our FB page. Thank you and have a nice day.